Good morning, everyone.
Morning, Your Honor.
Morning.
Ms. Williams, when you have a moment after you've arranged the screens, if you would initiate the live stream. Good morning to everyone. We are on, well, before the court this morning, I should say, is the case Bradley Miller versus Virginia Tally Dunn. This is cause number 20-15614. And I am going to go ahead and put us on the record in the matter. Before we get started, I do want to just reiterate that we are conducting this proceeding remotely pursuant to the orders of the Texas Supreme Court that authorizes us to conduct proceedings in this manner. Although we are conducting the proceeding remotely via video conferencing, the Zoom platform, please note that the court is still governed by all applicable rules, including the rule that precludes the recording of this proceeding by anyone without the court's permission, which I do not give. And therefore, this proceeding may not be recorded by audio or visual means by any person participating in the proceeding. As it relates to those who will now be introducing themselves to the court on the record on behalf of the parties, and in Mr. Miller's case, the party himself, I'd like for you to affirm your understanding of the manner in which we are proceeding and your agreement to do the same. And I'll start with you, Mr. Miller, your name and affirmation for the court.
Bradley B. Miller, pro se plaintiff, and yes, I understand.
And then, as we always do, any remaining defendants in this action should please state their appearances on behalf of their clients in the order in which those defendants appear in the style of the case.
Your Honor, this is Earl Nesbitt on behalf of defendants Danielle Diaz and Dallas County. I'm not sure where we are in the order of the case, but we will be addressing the matters before the court today. I do understand the court's admonition about recording, and we will comply with the same.
Thank you.
Your Honor, Elena Eric for the estate of Marianne Michalopoulos, and I understand the court and agree to no recording of this proceeding.
Mr. Grayton, are you intending to state your appearance on the record?
Your Honor, I'm Scott Graydon. I'm here on behalf of Judge Andrea Plumley, who has been dismissed from the lawsuit with prejudice.
Thank you. Is there anyone else on the matter who is here as something other than just an observer of the proceeding?
Your Honor, this is Jennifer Littman on behalf of Hockaday, who has been dismissed from the lawsuit. And I understand and agree to the court's instruction about recording.
Thank you, counsel. With that, I think everyone has introduced themselves who are connected with the proceeding in a capacity other than as an observer. And so I want to turn our attention then to the plaintiff's motion for declaratory judgment. I have read the motion and the response, and the court obviously is very familiar with the background of the case. And so I intend to pretty much give each side about 10 minutes because we've had a number of proceedings, and the court is well familiar with the facts and the allegations and claims that are contended as it relates particularly here to the two orders that are the subject of this motion. Having said that, Mr. Miller, I'll turn it over to you for your arguments in support of your motion.
Judge, this is Mr. Nesbitt. Before we delve into the motion, we have sought to have the court abate the motion and or continue the hearing. I think those would be matters better taken up before we delve into that. I think we can address them fairly quickly, but at this point, we believe it's inappropriate for the court to take up the merits of plaintiff's motion for declaratory judgment in light of the current status of the proceedings. I would ask that we be heard on that before turning to the motion.
Mr. Nesbitt, you may expound upon your request to continue the proceedings.
So, Your Honor, what we have filed is a plea in abatement and/or in the alternative, a motion to continue the hearing. We are seeking the abatement of the motion for declaratory relief because the nature of the declaratory relief that plaintiff seeks in this case requires that all parties that would be impacted by those declarations be active parties in the case. And what I mean by that is he's seeking in part to have this court, the extraordinary relief, to have this court find that the prior orders of the 330th court, two prior orders of the 330th court, were signed when the court lacked subject matter jurisdiction. And then he's further asking the court to void and vacate those orders. Those orders impact Ms. Dunn, who has been dismissed from this case, and she is an absolute necessary party. In fact, the case law says it's mandated that when a party is seeking declaratory relief, that all parties who have an interest and or who will be affected by that declaration must be made parties to the declaratory judgment action. Ms. Dunn is no longer a party in this case, having had all of her claims against her been dismissed for lack of subject matter jurisdiction, and therefore we do not believe that it is appropriate, nor do we believe that the court can render the relief, the declaratory relief that the plaintiff seeks. Additionally, Your Honor, we have, being my clients, defendants Dallas County and Judge Diaz, have filed a plea to the jurisdiction, very similar but not identical to the plea to the jurisdiction that was filed by Judge Plumlee and which was granted. And basically what our position is that the court does not have jurisdiction over the claims against Judge Diaz and Judge Connolly. The Texas Supreme Court has said that a declaratory judgment proceeding is a procedural remedy for cases that are already within the court's jurisdiction and cannot, and that DJ cannot independently establish jurisdiction. And the Texas Supreme Court has said in the Chenault case, a declaratory judgment is not available if a court does not have jurisdiction over the underlying case. And finally, in the Brooks case, the Texas Supreme Court has said that a court does not have jurisdiction to issue a declaratory judgment for parties not before the court. Ms. Dunn and Judge Plumlee are not before the court. It is unprecedented, quite frankly, and very unusual for a judge to be thrust in the position of having to defend in a separate declaratory judgment action the propriety of her orders. It is particularly inappropriate in my position, in my view, for the judge, in this case Judge Diaz and Dallas County, to be thrust in that position when the other parties who could be affected by the court's declaratory relief are not before the court. As I said, we have filed a plea to the jurisdiction. We are trying to get it heard now, and we expect to have it heard on July 7th. It looks like the possibility, but until this court determines that it has jurisdiction over the claims asserted against Judge Diaz and Dallas County, I do not believe you can entertain the declaratory relief. For that reason, we would ask that the court abate this motion for declaratory relief until such time as the court determines it has jurisdiction to entertain the relief, and or in the alternative, we're asking the court to simply continue the hearing until the court is able to take up and consider defendant Diaz and Dallas County's plea to the jurisdiction.
Mr. Miller, you may respond.
Yes, Your Honor. First, this motion for declaratory judgment was filed back in April 21st, I believe, when all affected parties were indeed still parties to the suit. There had been no dismissal hearings at that point, and no parties had been dismissed from the suit. Further, the defendants and Mr. Nesbitt have had a month and a half to file for continuance and are just now doing it at the last minute as of yesterday, I believe, June 9th. And just to remind the court, Your Honor, my First and 14th Amendment rights have now been violated for 5 years. I haven't seen my daughter in 3 years, and due process thus demands that this hearing go forward. I'd like to add that also all of the interested parties, even the ones who have been dismissed from this suit, are still being served with court documents through e-file. So they're well aware, as Mr. Graydon demonstrates, he is representing a party who's been dismissed from the suit, yet he's here and has appeared at this hearing. So I believe that there's no danger of any affected parties not being notified of their rights in this action. And as I said, they were parties when this motion was filed. And that's about it, Your Honor. Thank you.
Thank you. So, Mr. Miller, this is an interesting procedural issue that's been raised by Mr. Nesbitt, and I know that you will be, if you have not already, seeking a review of the court's decision to dismiss Ms. Dunn from the lawsuit. And certainly that's your right, and I respect that. The reason I bring it up is because the declaratory judgment statute states that a declaration does not prejudice the rights of a person not a party to the proceeding. Mm-hmm. And indeed, your desire here is, if you are successful in your effort with this motion today, is to effectively void orders that do impact Ms. Dunn's rights. And so I query whether the appropriate thing, the appropriate course is not to have there be review of the court's decision as it relates to the dismissal of Ms. Dunn. And if the Court of Appeals is disinclined to affirm that decision and remands that back to me, then that would be an appropriate time for the court then to consider the kind of relief that you have before the court today. Mm-hmm. I query, given the language that I just read from the statute, whether the effect of any, if the court were to side with your position today, whether that order itself would effectively be a nullity, because it really would not be able to impact the rights of a person who's not before the court. And indeed, those orders relate to Ms. Dunn's rights, and because of the posture of the case, she's not here. So I wanted to just put that out there. Obviously, I'm not here to give legal advice, but just trying to walk through this and use the resources in the best way, allowing you obviously to proceed with your appeal. And if the Court of Appeals thinks that you're right and the case comes back to me as it relates to Ms. Dunn, then the court would be able to hear the merits of the issues that you've raised, and Ms. Dunn would be able to advance her position. Your thoughts about that, Mr. Miller?
Yes, those are all very good points, which I understand. Even in the event that this procedural circumstance we're in does not allow a declaratory judgment ruling to affect Ms. Dunn's rights, it would in fact protect my rights to free speech and movement at the very least. Which would be a partial accomplishment, I guess, a partial accomplishment of the goals I'm seeking with this motion. So for that reason, I think it's worth going forward, even if as I said, and as you said, this ruling potentially would not affect would not be able to touch Ms. Dunn's rights because she's no longer a party to the case. I think it's still worth pursuing, and it could, Ms. Dunn's interest in this action could be addressed at a later point by the court, as you mentioned.
Okay. And then that's just a piece of the issue. The other issue that's been raised, as you know, is that there is a pending plea for Dallas County and Judge Diaz, and so the conventional wisdom is, of course, that the court deals with those jurisdictional issues first, because if the court does not have jurisdiction, then, of course, the court's orders are also null and void, as you have advocated. In another context, under a different scenario, but certainly that if the court does not have jurisdiction to be able to hear the case as it relates to those parties, then it would make sense then that the court would deal with that issue first before getting again into the merits of the issue. So I want to give you a chance to respond to that point. And let me just say this before you do. One course, rather than have us have this all over again, one course is, and Mr. Nesbitt, I'll give you a chance to chime in on this too. One course is for us to conclude the proceeding today, and the court could just hold its ruling until the plea is heard, so that we just don't have to come back and do this all over again. And then the court could issue a ruling contemporaneous with the ruling on the plea, if in fact the court overrules the plea. And it would be necessary to make a ruling on this motion. Maybe that's an efficient way to handle it and preserve the plea issue and give it the primacy that it deserves. Actually, Mr. Nesbitt, let me get your thoughts on that first, because it may short circuit things if you think that that's a course that would be acceptable.
Well, I with all due respect, I don't believe that's the most efficient manner to move forward. I think we need to address the jurisdictional issues first and foremost. But in any event, even if we have the argument today, it doesn't change the fact that Ms. Dunn and Judge Plumlee, who have been dismissed from the case, have potential, certainly Ms. Dunn and possibly Judge Plumlee have potential interest and rights that would be impacted by the requested declaratory relief. In particular, Mr. Miller is seeking not only a declaration of a void to void, not only a declaration that the court void and vacate an order signed by Judge Diaz in this motion. He's seeking the court to declare that an order signed by Judge Plumlee, who has already been dismissed from the case, is void and should be vacated. Were the court to ever entertain and or grant that relief, it would throw all of these proceedings into chaos. That's why he's not appropriate. I think the Texas Supreme Court has spoken on this issue and says that the court is required to determine whether it has jurisdiction before taking up any of the merits of the case. Now, if the court wants to hear argument today, I'll certainly argue. I do believe we can get the plea to the jurisdiction before you on July the 7th, which was less than a month away, according to Ms. Townsend. She emailed me this morning. So Mr. Miller has in the past asked the court to stay the entire proceeding so that he could hear from the Fifth Circuit as to whether his federal court would be reinstated. Kicking the ball down the road another 28 days or whatever might have give him the opportunity to get some clarity from the Fifth Circuit on that issue. And I don't think he's going to be prejudiced by simply waiting until we have the plea to the jurisdiction hearing on July 7th. So for those reasons, we believe it would be inappropriate and inefficient for the court and the parties to address the motion for declaratory judgment today.
You have not filed the plea yet?
Yes, we filed it.
You did file it. I see.
Yes,
okay.
ma'am.
All
It
right.
was filed yesterday.
I see.
And I spoke to the court this morning, the court clerk this morning, about getting a hearing.
Right.
They've not set a hearing because it didn't have a certificate of conference, even though the local rule says you don't need one on a plea to jurisdiction. I took that issue up with Ms. Townsend, and she promptly responded and has offered up July 7th at 10 a.m.
Okay. So, Mr. Miller, obviously the court is sensitive to the issues that you've raised in terms of the timeliness of it all and the desire to get swift adjudication of the issues that you put before the court. Mr. Nesbitt has properly advanced the legal proposition that the court really needs to deal with the jurisdictional issue first. But in an effort to try to balance both sides, what I can do is I can cause your motion, the one that you have here before the court today, I can visit with Ms. Townsend as soon as I'm off the Zoom this morning and have her set that to immediately follow the hearing on the plea, so that you still would get that adjudication of the matters. But I do think that probably it is the best course, given what has been raised here, for us to have that heard on the same day, subject to the court's ruling on the plea. Part of the reason for that is because in Mr. Nesbitt's arguments, he reminds the court that, you know, if the court were inclined towards your position and granted a declaration that voids the orders, I mean, that's exactly the thing that we heard from the Hockaday School in their motion before, that they didn't have. And therefore, they proceeded with the order that they had and have followed the order. And so if you were to come away with an order that declares void those orders, although I hear your arguments about Ms. Dunn's rights not being affected, it's hard for the court to really feel that in reality would not be the case.
Yes.
And so, as well as, of course, you know, other issues that we've talked about. So I'll have Ms. Townsend go ahead and get it set so that the court would hear it, subject to that motion by the county and Judge Diaz. Is there anything else on the matter, Mr. Miller?
Yes, I'd actually like to ask if we could hold those hearings on adjacent days, but perhaps not the same day. It's a little bit difficult for me to maintain a work schedule and prepare more than one hearing on the same day, if that's possible.
I'm happy to have it set on a day after that. The point is that the plea needs to come first, and
Understood.
we're happy to accommodate the request to set it on a different date. You'll contact the clerk and reset it on a date that works best for you. And
one more thing, if you wouldn't mind, Your Honor. I was a little worried about this exact issue when I filed my motion for declaratory judgment, and which is why I filed it as an emergency to see if this issue could be heard before dismissal hearings. I understand there's a protocol for hearing pleas to the jurisdiction, but just to address something Mr. Nesbitt said, this court gained jurisdiction over all the parties with the filing of the suit and the service of all the parties, of course. So I don't really think that's an issue. However, and of course, as I stated in the jurisdiction section of my motion, a motion for declaratory judgment can be heard at any time and in any court. And I'm not sure, I haven't researched closely enough to know how that relates to the protocol and timing of hearing pleas to the jurisdiction. But it does seem to me that if a motion for declaratory judgment could never be heard prior to a plea to the jurisdiction, it may very well be that you could never get a motion for declaratory judgment heard. So I just ask the court be sensitive to that issue. Thank you.
well, you can. I mean, if the court overrules the pleas, you know, it's not an infinite process that people just get to keep filing pleas. The jurisdictional issue ought to be a threshold point that folks raise early on. This happens to be a case that had quite a number of defendants, and so you know, people just sort of had to get in line with their motions, and the court took them up as the court's docket would tolerate. But the point is, those jurisdictional issues need to be dealt with because the court cannot make decisions when the court does not have jurisdiction. And if the court is persuaded by the arguments and sustains the pleas, then there would be no need to get to the merits issues, and it would be inappropriate to have gotten to them in advance of it. But I appreciate the point that you've raised, and I'll let you follow up with the clerks to get your motion reset on a date proximate to the date of the plea, but after the date that will be heard.
Thank you.
If there is nothing further, you all are excused.
Your Honor, just 2 points. Number one, we're fine if Mr. Miller would prefer to have, well, no, he said he does not. Never mind, forget that. The second point, so we're going to set it on on July 7th at 10 a.m. as suggested by Ms. Townsend. And Mr. Miller is okay with that?
July 7th, Monday, you said?
Now, I don't think it's a Monday. I think it's a Thursday.
It's a Wednesday, actually. Okay. That's fine with me.
Okay. And the other thing, Judge, just for purposes of clarity, we submitted orders on the plea and abatement and the motion to continue both. Are you going to continue the hearing, or are you going to abate the motion until, I just want to know which order you're going to sign.
I mean, the effect of it is the same, really, because we're setting the motion for declaratory relief on a date after
You're right.
the plea. And
Probably
so,
should be the continuance then, because our abatement order basically says abate until he can add all necessary parties. So it probably should be the continuance.
I will take a look at your orders. Is there
Okay.
anything else?
No, ma'am.
Thank you very much. Then y'all are excused.
Thank you.